Good morning. Welcome here. Today we'll hear oral arguments in the case of Seminole Electric Cooperative versus CSX Transportation, NOR 42110. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We have asked each party to make a short statement of their arguments, but counsel should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all of your pleadings, and there is no reason to repeat every argument. We have the following time allotments for counsel. Complainant, Seminole Electric. Cooperative has been allotted a total of 20 minutes. Seminole has asked to use 14 minutes for opening and has asked to reserve 6 minutes for rebuttal. If you wish to make a change to your reserved rebuttal time, please advise us when you begin your presentation. Counsel for defendant CSX will be allotted 20 minutes. Both parties have sought leave to make a PowerPoint presentation using materials previously placed in the record and have filed these materials in hard copy with opposing counsel and the board. We have received no objection to the materials proffered. We will have the pages used today as PowerPoint slides bound in the transcript of this proceeding. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you've been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. In addition, just a reminder to everyone, please turn off your cell phones. We will now proceed. Counsel for Seminole, please step up to the podium, introduce yourself, indicate if you wish to change your time for rebuttal, and then begin.
Thank you, Mr. Chairman. Kelvin Dowd of Slover and Loftus. It's my privilege to appear on behalf of Seminole Electric and its members and consumers, and I do not wish to change the allotment for my rebuttal. With me at counsel's table is Robert Strickland, the president of the Board of Trustees of Seminole Electric. I'd like to begin by addressing briefly the legal standard that should govern the board's determination of market dominance and the evaluation of CSX's claim of intermodal competition. According to CSX, the board need only decide whether some configuration of water transportation could work. There's no authority cited for this proposition, and this is not the applicable test. And indeed, it would stretch the inquiry to an unrealistic degree. The correct test is whether there are any alternatives sufficiently competitive to bring market discipline to a railroad's pricing. Now, the D.C. Circuit has added to that even if an alternative is physically available, inquiry must extend to whether it actually imposes a meaningful constraint on pricing. We submit that where an alternative doesn't actually exist, the inquiry should be even sharper and even more skeptical. Now, CSX does not claim that an effective alternative actually exists today. CSX's argument is that if Seminole would invest substantially more than $300 million in equipment and infrastructure, it could create an alternative. Now, the alternative that they propose to create from the principal coal origins for the Seminole generating station is an 8-step water delivery system. Now, on brief, CSX has expressed some mystification as to the 8 steps, so we have them up on the screen. Step 1 involves a move from the mine to the river by rail or truck. Step 2 is a transload to barges. Where the barges come from, according to CSX, we buy them. Step 3 is a barge movement down the river to New Orleans. Step 4, another transload to ocean vessel. Where the vessels come from, we would buy them. Step 5, a vessel move around the Florida Peninsula to Jacksonville. Step 6, a midstream transfer from ocean barges to river barges at Jacksonville.
Can I ask you about that midstream transfer? Are you aware of any other instances where that type of transfer is used?
There are midstream transfers that take place in the Gulf of Mexico and in the Mississippi River. There are no open ocean midstream transfers, and that's what CSX is proposing here.
Thank you.
Exactly where that would take place, we don't know, because there is no place in the Jacksonville port area where a midstream transfer of this type could occur. Step 7 is a barge up the St. Johns River to the Seminole generating station. Where would the barges come from? Again, we would have to buy them. And then finally, step 8 would be an unloading and conveyance system to SGS. Again, the dock, which does not exist, would have to be built. CSX's own numbers show that the capital costs for this scheme would significantly exceed $300 million, and we show that even that is understated. Now, the board has considered claims that shippers can build their way to competition before. In the West Texas Utilities case and the TMPA case, the board rejected those claims as not feasible due to cost. The cost of the CSX scheme in this case is over 4 times higher than earlier cases on a capital cost per annual ton basis. But really, that could be the end of the inquiry. Now, in our evidence, we've demonstrated that the CSX plan is not operationally feasible, it's not economically feasible, and there's no evidence that the alleged threat has constrained CSX's pricing at all.
Mr. Dowd, in this situation, who do you consider to have the burden of proof to establish whether market dominance is here?
Well, as the complainant in the case, Seminole has the burden on all key issues, including jurisdiction. In our opening evidence, we presented evidence that there was no effective intermodal alternative. In reply, CSX presented considerable testimony and material challenging that, and on rebuttal, we have responded in kind.
I saw in your in reading your opening, the evidence that I saw in there that made this for your argument regarding market dominance, to me it seemed like the 2 arguments that you made is, 1, the river is not navigable, and 2, that the study that you mentioned, the 2003 study, is evidence that the barge option is not feasible. Was there any other evidence in your opening statement or opening submission that would have established that there was market dominance?
Well, I believe our position on opening was not that the St. Johns River is not navigable, but that it is not a navigable waterway that presents an effective competitive option for SGS.
And do you believe that still to be the case?
That's still the case because the facilities, the infrastructure that would be necessary, even assuming that the draft of the St. Johns is sufficient to handle coal barges, the infrastructure that would be necessary at the power plant is infeasible as a matter of construction, and there is no place in the Jacksonville area where coal can be transferred from ocean vessels to river barges.
You, in the past, have used barge transportation to bring coal to the plants, correct? Before the CSX movements began?
Not entirely, sir.
That was partly.
For a number of years, Seminole used a barge transport system for a portion of the routing to Florida. It has never delivered coal by water to the plant. It's never been able to deliver coal by water to the plant. Throughout the entire time period, 100% of the coal has been delivered to the plant by rail by CSX.
Normally, barges, normally water transportation is considerably cheaper on a ton-mile basis than rail transportation, or especially truck or any other kind of transportation. Are there any potential barge movements that could be used to move down the Mississippi River as well as along the coastal waterway that would not require as much transloading as you project? In other words, can you use ocean-going barges that might be used on the Mississippi as well, or does that technology not quite exist? You know.
To our knowledge, ocean vessels which draft at 30 to 35 feet can't be operated on the Mississippi River.
Right. Okay.
And from the Illinois Basin, which is the principal source of coal for SGS, access to the ocean, to the Atlantic Ocean, would involve a rail movement on CSX.
The other last question I have on that map, you showed the barge moving through the Gulf of Mexico, and there's been some situations down there now. Do you think that could have any long-term effects on the ability to move coal traffic on the Gulf, or is that a temporary thing? I know you might not be able to answer that, but
I'm not an expert on the oil slick in the Gulf of Mexico, but I think that is an appropriate touch point for the assumptions that CSX makes regarding their system. One of the assumptions they make is that there will never be a delay. There will never be a storm, never be a wave event, never be a dock closed. never be a ship that's late and has to then sit at anchor and bring a new crew in. All of the many things which are a routine matter of maritime life, most of those are assumed away in the scheme that CSX describes. Something like the spill in the Gulf, to the extent that it interfered with shipping, would be yet another example of the kinds of events that would add to the cost.
Thank you.
Now, the two principal obstacles historically to moving coal by water to SGS are the unavailability of any transfer facilities at Jacksonville and the unavailability of a coal unloading dock at the power plant itself. Now, CSX has proposed a system whereby ocean vessels would approach the port of Jacksonville and would transfer coal in what they consider to be what they call midstream, but it would be done about 1.5 miles northeast of the entrance to Jacksport Harbor. That's in the ocean. And you cannot physically transload coal from an ocean vessel to a river barge in the middle of the ocean. River barges are not certified for ocean operation. They could be swamped even in normal seas. And the cranes that CSX proposes to use are not certified for ocean operation, nor are they usually mounted on barges. They also propose to fleet or store the barges approximately 20 miles away from where the transfer from the ocean vessel would take place. Again, a highly inefficient operation. And you take these facts together, and it shows that the scheme they envision simply won't work. And it's significant that no such operation has ever been conducted in Jacksonville. Now, on brief, CSX suggests that the transfer could be moved into protected waters, into the intracoastal waterway. But that won't work either. The intercoastal waterway can't handle ocean vessels. The intercoastal is dredged to a depth of 12 feet. Ocean vessels draft 30 to 35 feet. So whether it's a question of the river barges trying to get out to the ocean to meet the ocean vessel, or the ocean vessel trying to get into the intercoastal to meet the barges, the system won't work either way.
Let me ask you a quick question on, back in 2003, you did this, I believe your client did this BTG study, and wouldn't you consider that to be, since it wasn't made in anticipation of litigation or during litigation, to be the best evidence of what we have here to show whether the barge system would actually work?
No, I would not, because the BTG draft clearly states, first of all, that it offers no opinion on the feasibility of a barge operation. And secondly, at several key points in the draft, the authors point out that infrastructure that would be necessary to implement a particular step doesn't exist. And the unavailability of transfer points in Jacksonville is one of the points that's specifically mentioned. Now, I think it's important to put this draft in context. CSX attempts to suggest that a statement by the consultant in 2003 is the equivalent of a conclusion drawn by Seminole Electric. It is the case that for a number of years, Seminole had experience moving coal part of the way by barge. They have considerable experience and understanding as to what works and what doesn't work when it comes to water transportation. And when they received a draft that proposed a transfer from ocean vessels to barges in the Port of Jacksonville when there were no facilities for that, and an unloading operation at SGS using a dock that can't be built, they concluded to put the draft to one side, and no further steps were taken to pursue it.
Now, Mr. Dowd, if I could, I'd like to explore with you a little bit and ask you to help us think through what I see as one of the key issues here, which is really what are the boundaries and or expectations when we think about self-help in the case of a shipper. Looking at the record here, you may well have a strong case. I'm not going to speak to the merits here at this moment, but certainly it's clear to me that your client's not what I would call the poster child of captivity. You are right on a navigable waterway. You were located on a navigable waterway for the very reason of having the barge option. That's clearly spelled out in the environmental permitting documentation when the facility was opened. Your client deserves credit for that. That's a smart strategic business decision. Your client relied in large part on maritime transportation of commodities for a long time in the past, and you're only 3.5 miles from a competing railroad, Norfolk Southern, that has trackage rights into the Georgia Pacific plant. At what point help us think through why we shouldn't ask your client to implement self-help steps to see competitive options? There are many shippers around the country who would love to be located on a navigable waterway and also 3.5 miles from a competing railroad. We get those cases all the time, and we usually don't have to spend too much time on the issues that are presented here. But it's difficult. I submit it's not an easy judgment call to know whether a 3.5 mile build out is reasonable, or whether building a wharf or a pier and the other infrastructure for barging is reasonable. But help us think through why how we should approach some of the issues I've just discussed.
Well, Commissioner Nottingham, first of all, I don't believe there is a poster child for captivity. I think every situation has to be judged on its own facts and on its own merits. If a hypothetical utility had a railroad 3 miles away across open desert, they would be in a considerably different position than a utility that had a railroad 3 miles away across the Everglades. The facts of this case are that SGS, when it was permitted, the important consideration was water supply, not water transportation. And its original site certification permit is for rail delivery, not for water delivery. The fact that the power plant is 3 nautical miles from the river only then moves into the question, how accessible would river transport be to that facility? And we've shown that it is not accessible, because there is no feasible way to get the coal from the ocean to the river barge, and there is no feasible way to get the coal from the river barge to the power plant, because there's no property available for the construction of the kind of large industrial dock facility that you would need in order to unload this coal. And we have photographs of that, which I think have been submitted to the board, and they're on pages 17 and 18 of our exhibit 2B1. So I think the answer to your question is that there's no bright line rule. The statute speaks of effective competition. The cases have interpreted that as a reasonable, feasible alternative that has a meaningful constraining influence on the railroad's pricing. In this particular case, when the parties were unable to agree to a new contract, the prices were raised by multiples of the former levels, and not a single ton of coal was lost by CSX. The financial analysts, in public statements, applaud this litigation as a sign that CSX is aggressively maximizing its market power and aggressively pricing its service. So I think the answer to your question is that, as the board has done in the past, you have to look to the specific facts of each case. And the facts of this case, Seminole Generating Station is captive to CSX.
So if I can just properly understand what you're saying, are you submitting that the board should expect some self-help, but the self-help in this case would be unreasonably too expensive and impracticable? In other words, if we changed the facts here and said your client was located next to a major interstate highway, but for some strange reason the connecting road system just didn't quite reach the driveway of your facility, it was a 100-yard gap of some unpaved dirt that needed to be improved in order to give you access to the interstate highway, you wouldn't be here saying that the truck option is not even possible to look at, putting aside the cost of trucking. But in other words, at what point do we go from the completely easy sort of proverbial open court layup of self-help versus the crossing of the proverbial Andes Mountains with the highway?
Well, I think that there are plenty of examples in the real world of shippers, utility companies that have constructed facilities in order to access alternative rail service. Certainly, those can be looked to as a template of the kind of cost-benefit analysis that the utility does when trying to determine how to best invest their capital. In the case of Seminole Electric, They went to considerable trouble and expense many years ago to use a barge transit system for a portion of the haul, but were never able to avoid the rail service for the delivery. That is, I think, highly significant, even in the face of the repeated references to that prior barge delivery system. So, I'm sorry.
Mr. Chairman, could I just ask one last quick question to close that line?
Sure.
Thanks. On the issue or question of the 3.5-mile distance between your client's facility and the Norfolk Southern served Georgia Pacific plant, I understand your client actually studied that possibility, and the costs were far less than this $300 million that you've referenced for the barge option. Could you elaborate on that, or without getting into anything that's confidential, and also put it in context of how much your client is spending per year on coal purchases and transportation, so we have some sense of the relative reasonableness of spending $60, $70, $80 million versus 300, for example?
Well, the idea of a build to Norfolk Southern, I would submit, is not really an issue in this case, because it was described as infeasible on opening. It was not challenged by CSX on reply, and therefore the matter should be considered closed. Without getting into confidential information, I can tell you that there was a disqualifying obstacle to that plan in the form of the unavailability of the use of property owned by a third party, and then there was a further obstacle in the need to cross major highways and cross CSX itself with a rail line. I can't go into more detail without getting into highly confidential information, and we're all trying to avoid that here today.
Well, my understanding for a moment here is that did you have any negotiations at all with Norfolk Southern as to their willingness to enter into a contract if indeed you decided to pursue that option? Because quite frankly, very often what utilities have done, or other firms that were captive have done, is they have threatened to build out or build in order to provide competition, and that very threat has caused the railroad to re-enter into negotiations and perhaps come up with a more favorable rate to the shipper. So was there any attempt at all at talking to Norfolk Southern, or was that never advanced?
I think that the more recent experience has been that the threat of construction has done nothing to assist a utility in negotiating. It has to be the actual act has to go forward. You have to put the stake in the ground, if you will.
Well, you need to begin, say, doing surveying and that sort of thing, or begin to negotiate acquisition of property. Wouldn't you have the eminent domain rights, however, if you're going to begin building to the Norfolk Southern? There would be, you would have eminent domain rights, as railroads have, to acquire private property or to cross highways or to cross land owned by other railroads. I mean, those tend not to be insurmountable barriers.
Well, Seminole Electric's not a railroad; it's a utility.
No, but the railroad you're connecting to would have eminent domain potential. So it's a Norfolk Southern building down to Seminole.
However, there is no real record of existing railroads doing that. The record has been to the contrary, that the railroads are unwilling to undertake construction to encroach on another railroad's market share. If the shipper's willing to build out, then they're willing to serve, but it doesn't go the other way around.
But the shipper builds out. The shipper creates a short line railroad to connect itself to the Norfolk Southern. I understand that. The other thing you mentioned about the difficulty of building through the Florida Everglades. This land would have to go through the Florida Everglades. My understanding is the Florida Everglades are considerably south of where you're talking about right now.
They are. My reference to the Everglades was in response to Commissioner Nottingham's question about is there a standard for what you should be able to build, and I was just trying to point out that it depends on where your 3 miles go.
Right.
If they go in the middle of the desert, it's one thing. If it's over protected wetlands, the Everglades, or something else, it would be something entirely different.
There's no mountain ranges in Florida either, but nonetheless, it's not through the Everglades. But it was my only question. Okay, thank you.
Thank you very much, Mr. Dodd. You'll have 6 minutes on rebuttal. And Mr. Motes, please step up to the podium and introduce yourself, counsel for CSX, and begin.
Thank you, Chairman
You
Elliott.
have 20 minutes, by the way.
Thank you, Chairman Elliott. May it please the board, I am Paul Moats, and I'm privileged to represent the defendant, CSX Transportation, Inc., here today. With me at council table to my immediate left is Mr. Seth Schwartz, who is president of Energy Ventures Analysis. He's the primary author of the expert report that we put in on reply. And to his left is Mr. Peter Schutz, who's vice president of federal regulation for CSX. Mr. Chairman, I know we have a serious problem here today with this case, and I believe some of your questions of Mr. Dowd foreshadowed that. The problem is stated very simply. In their complaint, Seminole said two sentences about market dominance. They said there are no navigable waterways of the plant, and the only way they could ship coal was by rail. We answered and denied that, said absolutely untrue. We'll demonstrate that there are alternatives. 11 months later, because that's how long it was from the filing of the complaint to their opening evidence, 11 months later, they come in their opening and filed literally 3.5 pages on barge alternatives. A little bit more than that, I don't remember, maybe 12 or 15 under what was called qualitative market dominance, but only 3.5 pages dealing with why a barge alternative would not be viable. We came in, as you know, in our reply, as we're entitled to do, in our one and only filing that we're permitted to make in a standalone cost case on all issues, and put in what we respectfully submit as a very substantial probative study by Mr. Schwartz and his colleague, Mr. Stamberg, supported by lots of other evidence demonstrating that, yes, it is a much longer route and there are transloads and certainly there are issues that need to be dealt with, but this utility knows how to deal with them. This utility in the history of its plant has moved more coal to that plant by water than it has by rail. This utility spent $100 million to buy its own private barge fleet when it built that plant. And CSX, in a very aggressive move, essentially helped them buy out of that contract when we first got this business by rail. That helped them with such a good rate package that they were able to get out from their barge contract.
Mr. Moats, I have similar concerns about the initial filing by Seminole and that it was a little bit of a skeleton product, and I understand. I think that is a serious concern for the board because the process won't work if you can't respond to the full argument. One question I do have, though, is just by looking at the increase in the rates that came about here once they asked you to quote the rate, isn't that very strong evidence of market dominance in itself, even without all the evidence?
With respect, no. Why not? Because that contract I referred to that they entered into, CSX entered into with Seminole to help Seminole buy out of his barge fleet, was at a very low rate. And CSX did that consciously. It wanted the business. Over time, over the period of that contract, that rate got lower and lower compared to the other utilities in Florida, compared to what the market was doing. By the time their contract expired, they were way below the market in Florida, and CSX attempted to negotiate with them for a new contract at a higher rate. I won't say it was as high as the rate that's being challenged here today. I don't think the board will be shocked to know that railroads typically will make a better rate in a contract than they will in a common carrier rate, because there are other items in a contract, minimum volumes, sometimes deals on equipment, deals on scheduling, lots of other things, refunds. No, I don't, with all respect, think so. Our belief is that we brought their rate up much closer to the market for other Florida utilities, water served and rail served. They're now higher than they were, no doubt about that. But in our reply evidence, you'll see there's a chart where we show they went from the very lowest delivered cost coal-fired utility in Florida to about the middle of the range.
Doesn't the delivered cost chart, though, really take into consideration the cost of coal also? And as a result, isn't that not really a good indicator of whether the rates are high or low?
Well, your comment is accurate. Yes, it does obviously take into account the cost of the coal, and they have a good deal apparently with Alliance, for whatever period of time, and I submit not as long a period of time as they have said in their evidence. If you look, we've referred you twice in brief to the actual contract, which is in the record. It doesn't, they're not bound to that as long as they say they are. But yes, they have had a lower coal price. They've done a good job of negotiating for those coal supplies. But at the end of the day, they are, in a market too, and they are delivering a product, electricity, to ratepayers in Central Florida, and we submit that chart to show that they're not disadvantaged vis-a-vis other utilities.
But you would admit that the transportation cost per se, taking out the cost of the coal, the transportation cost that in the proposed contract would be substantially higher than the transportation cost paid by other Florida utilities, or are you saying that the transportation cost that CSX is asking Seminole to pay is similar to what other Florida utilities are paying to transport coal, taking out of the equation the mine cost of the coal?
Mr. Dowd submitted an exhibit he'll no doubt use here in his last 6 minutes. The last of the charts he put in that shows mills per ton mile of certain selected utilities, and shows that Seminole is way far on the right. It's paying more on a mills per ton mile basis. Well, first of all, the board doesn't determine rate reasonableness on a mills per ton mile basis. We all know that. But also, I ask you to look hard at that chart and look at what those utilities actually are. They have contracts. And they all have different circumstances in which they negotiated those contracts. Again, the contracts for some of those utilities that are to the left of Seminole, if you can visualize that on the chart, have other kinds of provisions. They get other kinds of benefits and other kinds of concessions, and CSX gets some too, notably certainty of volume and length. If I may come back before I lose it, though, Chairman Elliott, on the fundamental fairness point, this really, I think, is important. They put in, as I said, 3.5 pages on opening on why a barge alternative wouldn't work. On rebuttal, they put in 133 pages. And, we have literally no chance to respond to that other than in brief and in my obviously inadequate efforts here today. I'm not an expert. I'm not testifying. I'm a lawyer arguing from the record. Your rules, and you know very well what they say, you were very clear in your market dominance procedural rules to say that a complainant or party with a burden of proof must put in all of its evidence in its opening case on the issue as to which it has the burden of proof. They didn't do that. They didn't come close to doing that. And I submit that if you allow them to get away with that you're going to give a signal to other complainants that is not going to be a very helpful and fair one. And again, as you know, railroad in these cases has one filing and one filing only on all issues.
Mr. Motes, this in some ways touches on that point, I believe. But do you believe the board is prohibited either procedurally or legally or for any other reason from examining the rail option, the 3.5 miles I referenced earlier that would connect Seminole's facility to the Georgia-Pacific plant that's served by your competitor? Are we not allowed to look at that because there's not enough in the record? And if so, why isn't there enough in the record on that?
I think the board is fully within its power to take official notice of things of which it has knowledge and in which there is public information. And there is public information, as I recall, about their exploration of a possible build-out to Norfolk Southern some years back. We did not make that our case in our market dominance submission. We candidly thought that the water alternative was very real, very viable, and we thought we could well support it. I guess maybe in a sense, Commissioner Nottingham, you're asking me why didn't we make that argument, and I guess the answer is we had to pick and choose our battles, and we went with the water option.
I worry that. In
light of your question, maybe I should rethink that. But.
No, it just I just worry that the board may be inappropriately handcuffed. It may well be in Seminole's interest not to explore the 3.5 mile build out on the record, and it may well be in your client CSX's interest not to demonstrate how simple a proposition that may or may not be, because your client's corporate policy may be very opposed to pointing out the ease of access to a competing rail service. So then we're left with a record that strategically is lacking on a very key, in my view, a very key area of exploration for the board. We don't seem to know the details here. We have just clarified that it's not the Everglades. It appears to be a pretty flat terrain. We know on the record that it's only 3.5 miles. We know on the record there's been some examination of the feasibility by Seminole of that build out. The dollar amounts referenced in that examination are far less than the dollar amounts referenced in the barge infrastructure build out. And so, the question is begging to be answered, in my view, from the board's perspective. How can we better understand that? Because in my view, a 3.5 mile build out could very easily fall within the realm of reasonableness for self-help that we would expect. at the same time, a 3.5 mile build out could be the opposite of reasonable, depending on the terrain and the environmental permitting and the costs. But without more on the record there, it is frustrating, and I guess I would have expected your team to help build that record out, perhaps more than I would have expected Seminole to, but in any event.
I'm sorry about the disappointment. I'm sorry, as I'm standing here, that we didn't put in a lot more about that. I can tell you, as you know, the Norfolk Southern is a fabulous, terrific railroad. It's the major competitor of CSX, and I don't think it's not our instinct normally to try to, if you will, develop new marketing opportunities for the competition. I think they're fully capable of doing that.
I would add, I guess, that in my view, we shouldn't look in the record for glowing testimonials from Norfolk Southern in a case like this about how eager they are to serve Seminole. That to me is irrelevant. If the line extends to that to Norfolk Southern's track, on CSX's track, on which Norfolk Southern in this case has trackage rights, it doesn't matter whether Norfolk Southern's enthusiastic about that or not. They have a common carrier obligation in that scenario to quote a rate. And so that is one of the things in some of the relevant case law, including the Tempa case, where I do wonder why in the past this board or our predecessor agency have put much stock in the enthusiasm of the demonstrated enthusiasm of the purported or proffered competing railroad to provide service. That to me is not relevant to when there's a common carrier obligation there.
Well, I'll say what I think you know. You clearly have the power to direct these parties to submit additional evidence on that issue if you thought that was important. And listening to you here today, I'm beginning to think it's pretty darn important. So, but that is within your discretion. By the way, I'm not high tech. I don't have PowerPoint slides. I gave you hard copy slides that I hope you have. But the two things that are up here on the easels, obviously this is a blow up of something you have. It's a satellite overhead of the St. John's, down to their plant, which is here, and the Everglades are way over here somewhere on the floor. So, Vice Chairman Mulvey, you're absolutely right about that. And that is a fuel barge going past the Seminole plant in the quote-unquote non-navigable waterway, which, we thought the picture speaks 1,000 words. There is, and our evidence shows, there's all kinds of commercial barge traffic on this river today. Are there tows going to utilities? No, they're the only utility up there on the river. But we think we've demonstrated that it is, in fact, very, very feasible.
Let me ask you a quick question, just about the general project itself. I mean, we're talking a substantial amount of money and probably a very complex process. How long do you think, or does your expert think that this type of project would take? Is it going to be, are we talking a year, 10 years? I mean, if it's 10 years, obviously, the market dominance argument starts to shrink away.
It's not 10 years, and you have a volume. Again, I'm not going to quote from it here, of this BTG report for 2003. They are, of course, very interested in not talking about it and saying it's a draft and we never agreed to it and so forth. And that's true. They didn't go do this. But this is the same consulting firm. They have come in on rebuttal and put in a very big report that basically undermines most of all the important findings that they made here. And this includes, if you have a chance to look at it, and I strongly urge you to look at it, and I think from the nods, some of you obviously had, a lot of the issues that they raised for the first time in rebuttal that we couldn't speak to are addressed here. One of their own people says that the water outlet is exactly the place where you put a dock. That's at page 004785 of the draft. What about the issue of all this permitting? They've raised a lot of that. Pages 4803 to 4812. This consultant back then addressed that. They didn't say it was infeasible. It would take some time.
My question's not as much towards feasibility here as timing.
Cost and timing.
If it takes 10 years to build it, to get the permitting, and then that would still have CSX with an ability to be market dominant for that 10-year period.
I wouldn't suggest it could happen, in 6 months.
Right.
It certainly wouldn't be 10 years. I'm not the expert he is here, but I'm guessing it would take maybe no more than, I'm going to say a year, and you're going to say a little over 1 year. Okay, well, okay. But the reality is too, yes, it's $300+ million to go out and buy all the pieces of that chain, and that is the way we costed it because they owned their barges before. We assume that's what they want to do. But obviously, you can lease these assets too. Right now, especially the water industry would love to have that kind of business. There are lots of barges available. There are towboats available. The transloading, again, I'm all over the place here, but I've got to be a little bit of a witness. This issue about transloading the open ocean, that's called the Jacksonville anchorage. The U.S. Coast Guard told us that's where they would recommend this kind of an operation take place. It isn't in the Bermuda Triangle. It is off the mouth of the St. Johns River. It is out into the beginning of the ocean. But we think that's feasible. On those high wave days, there were 49 of those in 2009. How many days does that leave to be able to do the operation? And even probably a little more interestingly, again, if you look at this, I love this report, this BTG report. They say at page 004782, if you all have it there and would look at this with me, I really would like you to just take a look at this if you can. It's page 1-2 of their numbering, 004782 of ours. And look at the second paragraph from the bottom of the page. It's only 3 sentences, and I'm not going to read it out loud, but that I submit as a complete answer to this nonsense about, there's nowhere to transload. There certainly are. There are lots of places, and there are people who like to do that business as well. On the issue of the conveyor and the right-of-way, again, on the little exhibits that I hope you have, I'm not going to put them up here. We give you some successive shots from the video that we submitted into evidence to march you sort of up that right-of-way from the water intake on the bank of the St. Johns up to their coal pile. And you can see it's not real wide, but we think it's wide enough or nearly wide enough for a conveyor. Again, their consultants addressed the relative ease of broadening that easement or, if necessary, purchasing that property. In their brief, they describe at page 13 of their final brief that is the land that is, quote, already fully occupied. Look at those pictures. Does that land look fully occupied? It isn't. I mean, it's mowed beyond the pump house up to all the way to their plant. Can conveyors be used there? Again, look at the last photograph I've given you of their plant. You'll see conveyors in the plant today moving coal from the pile to the reclaimer. They move limestone. There's common use of conveyors to move coal and transload operations much longer distances than we're proposing be done here.
One of the things I'm interested in is transloading in the ocean. I mean, Seminole made a case that it really can't be done. And you're saying now that the Coast Guard said that the Jackson anchorage, a mile outside of the mouth of the harbor, is okay to transload from ocean-going vessels to river barges, and that river barges then could safely navigate that part of the ocean into the channel and up the St. Johns River. This is becoming important now, obviously, because of what's happened in the Gulf.
Yes.
I think that any new activities that are proposed that could, in fact, result in any more degradation of our coastal waterways is to be looked at with askance. So the question is the certitude that you have that, in fact, this operation can take place, this transloading can take place 1 mile outside of the mouth of the St. Johns River.
Yeah, I'll refer you to our reply evidence. They made this argument about you can't do it out there in their rebuttal, so we haven't had to be able to come back. But yes, we have work papers behind his report that shows that it was the U.S. Coast Guard that said it's the Jacksonville anchorage area, primary caps, by the way, is part of the Gulf, and not the Gulf, the Atlantic intracoastal waterway, where they would recommend that kind of transloading be done. If there was a high wave day, if there was a storm, of course, you would suspend your operations. You would bring those barges back inside the mouth of the river and do it on, the next calm day. But again, I don't want to lose this point. The page I just referred you to, and here by their consultants, tells you that there are multiple places that it can be done within the river itself before you get to the city of Jacksonville. And, Mr. Dowd's quote in the beginning from his the briefs, and he said we had the wrong legal standard and he has the right one. Well, yeah, he has the right one. I agree. West Texas sets out the standard, and that isn't a standard. That little piece he quoted from was our wrap-up and saying they've thrown all this stuff at us in rebuttal about this isn't feasible, that isn't feasible, and all we said was the board doesn't need to know precisely how a dock would be designed or what path the conveyor would take. You only need to know that it would work, and that's what we've attempted to show. If you need to buy another 50 feet along the easement to expand it to get the leg of a conveyor down, that can be done.
One follow-up question on that then. I mean, in this country, and I guess with our technology and our creative ability and our entrepreneurs, entrepreneurial spirit, you can pretty much do anything. A long time ago, a Nobel Prize-winning economist wrote an article saying that what if we never built the railroads? Were the railroads critical to U.S. economic development? And he showed that you could actually build canals all over the whole country and replace the railroads. Now, the question was whether or not that should have been done. The question was whether it was feasible, what it could have been done, and what that would have meant to long-term economic growth. It would have been a cost, but it was not that great of a cost. I think about 3 percentage points in GDP 100 years later. The point being is you can do pretty much anything if you want. So anytime a utility is, say, it says it's captive, a railroad can always point and say that, well, if you do this, regardless of what it is, it can be done. You can have an alternative. Is there any cap? Is there any limit as to how much the utility would have to pay in order to take advantage of these alternatives? I mean, we have Seminole saying it's going to cost them $300 million. Well, if it could do that and spend that, and it could have a water alternative, is that still a viable option? And how do we determine when spending is too much in order to take advantage of the alternative?
I don't have an easy test for you. I can tell you when they analyzed it for business purposes and not litigation purposes, nobody said it would be too expensive. Would it be expensive? Yes. But don't forget, if they do it, they're out of their CSX contract. They're not paying that rail. You asked the question earlier, Vice Chairman, what do they spend in a year? I'm told last year was about $230 million, but last year was a really bad year for them. They had a lot of outages at their plant. Their coal deliveries were down. Normal year, it's about $350 million. Annual revenues for this utility about $1.4 billion. It's a big company. It can finance these things, or if it prefers to lease them in the open market, it's capable of doing that as well. My colleagues here remind me on the issue of their high wave days, or, it's not the best day to load the barge in the Jacksonville Anchorage because you suspend operations. The railroad has to do that. You all know what happened after the hurricanes in the Gulf and what happened to CSX and Norfolk Southern, and the very significant damage to the infrastructure, and they have to suspend operations, but they find a way to get it done.
Mr. Motes, if I could ask, do you believe that the record before us demonstrates a history of the barge option in the past creating market discipline and enabling as you referred to earlier, a very, very competitive low rate at the very beginning of CSX's modern-day relationship with Seminole? In other words, don't we have in the record a very real example of the barge alternative creating a very meaningful example of market discipline?
Mr. Nottingham, I think, is stark. It's real. We can't argue about whether it happened. It happened. They invested $100 million. They moved coal for years and years in those barges to Port St. Joseph, by the way, down there on I'm not very good at geography, the Gulf part of the Panhandle, I guess, in Florida is where it is. And it was short haul railed from there. We didn't even get the haul from there, by the way. We got the haul from a short line railroad that brought it to us at Chattahoochee, I think. I'm learning Florida geography. Chattahoochee, Florida. And yes, the railroad sure got the message, and the railroad was very aggressive. Maybe you could say in retrospect too aggressive in the way they priced that contract for that length of time, but I'm repeating myself, but it's a darn good point. By the time that contract expired, they were way below the market, and the barge option had done that. And as we renegotiated with them, we were very aware of the fact that option, they still could go pursue that.
So if you just run the numbers briefly in general fashion, you reference about a $300 million a year coal purchase budget roughly for Seminole. Your contract periods often run 10 years. Is that fairly common? I don't want to get into business secrets.
Coal supply or transportation? For
transportation or either or.
Very few 10-year contracts anymore. That was more the norm maybe right after Staggers and into the early 90s. But 5-year contracts are fairly common for movements of this type. Again, that kind of a contract would certainly come with a volume commitment, quite possibly a liquidated damages provision for failure to meet the volume. It would come with provisions dealing with who provided the equipment. There would be other items of economic importance in that kind of a contract.
So what type of percentage savings do you proffer that the Seminole might be able to achieve if they were to build out their barge option? Are they talking about 10% a year, 20, 30?
I don't think I can answer that. I have something I think I have in mind, but I'm not sure. I don't want to say it because I'm not sure I'm right, and I'm not sure it's in the record. So it's a great question.
Thank you, Mr. Motes. Mr. Dowd, you have 6 minutes on rebuttal.
Thank you, Mr. Chairman. I'll try to move through some of these points as succinctly as I can. First of all, on the question of the submission on opening and the submission on rebuttal, we did on opening present evidence, verified evidence and narrative that the barge option or the barge hypothetical was not feasible, and that the notion of building to Norfolk Southern, while considered, also was not feasible. On reply, CSX chose not to challenge the issue of intramodal competition. I would submit that the board's rules and policies are quite clear that that issue is closed. In your decisions in Duke and in Carolina Power and Light, where you laid out your guidance on the proper scope of rebuttal, it was clearly stated that if a shipper presents credible evidence on opening and that evidence is not challenged by the railroad, the shipper's evidence will be accepted. This is not a case of judicial notice. Something like a build out to another railroad would be very fact specific. It would be an issue in contention and is not one that's suitable for decision based on principles of judicial notice.
What about to Mr. Motz's point regarding your initial filing and then having such a substantial rebuttal filing, not permitting them to really respond after that? It does raise some concerns.
What CSX was not able to engage in was rebuttal, and that's how the rules are organized. Everything that Seminole submitted on rebuttal was in direct response to an argument made by CSX on reply. Market dominance is not the same as standalone cost. Standalone cost, the board has set out a structure and an organization of all the specific components that need to be addressed. And it's very clear to all parties exactly what has to be addressed in depth in each and every case. Market dominance is a legal standard. And there, the appropriate analysis is whether and to what extent what is submitted on rebuttal is new evidence or is it responsive evidence. And in our case, everything submitted on rebuttal was in direct response to an argument made by CSXT on reply. Now, I'd like to touch briefly on this issue of market rates. And I cannot get into details because of confidentiality concerns, but it is in the record, and it is not the case that the rates that were initially agreed upon in 1998 were below market rates. And we have evidence in the record in the highly confidential sections which demonstrate that, and I would refer the board to that evidence. Secondly, on the issue of delivered costs into Florida and the notion of Seminole's status vis-a-vis other utilities, it was correctly pointed out that delivered cost does include the cost of the coal, and therefore it masks the relative rail rates. The chart that we submitted, which is up on the screen today, we didn't select these utilities out of thin air. These are the utilities that CSX selected to do their delivered cost comparison. The purpose of this chart is to expose the difference between the two. And as the D.C. Circuit held in the coal exporters decision, if a railroad has the ability to price discriminate in order to secure the economic rents that are made available by other links in the supply chain, that is a classic indicator of monopoly power. And that's what we have here. In terms of the question about the construction of the dock, and I think it's important to differentiate between the dock and the conveyor. CSX spends a lot of time talking about acquiring land and refers to the BTG draft and has in the photograph the mode property. That's all for a conveyor. You don't get to the conveyor unless you can build the dock, and there is no space to build the dock. In terms of time, by comparison, the third unit at the Seminole generating station, which is a brownfield site, it was already set aside for a third unit. It was already preliminary in the site plan. It was already preliminarily intended to include a third unit. And it still took 3.5 years to get the permits. And even then, they didn't get all the permits, and ultimately the plan was shelved. That's on a brownfield site right next door to an existing use. To do something like build a large industrial coal dock on a greenfield site in the middle of a residential neighborhood, and we have the photographs that demonstrate whatever you see from the river, you see trees. You go behind those trees, and you see residences, and there are no for sale signs in any of those yards. To build a large industrial coal dock on a greenfield site would take, I would assume, considerably longer get permitted, much less to get it built.
What is it? How is that site zoned today? Is that site zoned residential or zoned industrial or zoned? We'd have to have changes in the zoning laws, or the zoning laws could accommodate building the dock?
Among the regulatory permits that would have to be, or the regulatory actions that would have to be satisfied in order to attempt to construct a dock like that, is a rezoning. But that may be among the easiest. There are other permits and approvals that would have to be required, including a change in the Putnam County master plan and a variety of environmental and other regulatory approvals that would be necessary, all of which would be met with considerable organized community opposition.
Mr. Dow, let me make sure I understand your point a second ago. You pointed out that, did I hear correctly, to get the permitting necessary to build a new coal-fired electric generating plant, it could take a couple years or longer?
No, that was to build a third unit at an existing.
Okay, third. You're talking about, but you're talking about the Clean Air Act as the driving factor there.
No,
typically.
I'm sorry. It was also the Florida Department of Environmental Protection, the various county requirements, the Army Corps of Engineers. It was a variety of regulatory hurdles that had to be cleared, and that was for a third unit at a power plant that already had 2 units. You were simply adding on. What you'd be talking about in a dock on the St. Johns River is a brand new industrial facility on a greenfield site surrounded by residences.
I'm just not sure I follow the comparison. I mean, I'll look again in the record to see if the comparison's there, but there are docks, and sometimes in that part of the world they're called wharves, built every day in Florida. Building a dock is not necessarily the same thing as building a heavy-duty industrial energy generating facility that has extensive potential Clean Air Act ramifications. You're talking about barges pulling up to a dock, unloading some coal onto a conveyor. I'm not quite sure I get your premise a minute ago that it would be obviously, in your view, more complicated to build and get permitted a dock than it would be an expansion of your electric generating facility.
Well, first, we're not talking about a recreational dock or a wharf for pleasure boats. We have photographs, there are pages 17 and 18 of our Exhibit 2B1, that show the dock at Plant Crist, which is in Pensacola. And that is not a pleasure wharf. That's a large industrial facility. There is a photograph of the type of crane that CSX posits could be installed on that dock. It's enormous. It's an enormous piece of equipment. And the comparison that I'm drawing is in the amount of time it would take to get permits to construct an industrial facility like that on a greenfield site surrounded by residences, as compared to what it took to simply add on to an existing power plant on a brownfield site. The latter took 3.5 years. I would submit that to do the former would take considerably longer than that, and that's before you begin construction. I see my time has expired. And I
thank you very much, Mr. Dowd. Thank you very much, Mr. Motes, for your excellent arguments. We'll take the matter under advisement, and the hearing is now closed.